Ok. So, bom, pessoal, eu vou falar em inglês para apresentar a professora Toni. Agradeço aí a participação de todos vocês e deixa eu fazer essa apresentação breve aqui. It's my pleasure and my privilege to welcome you for this event here with Professor Toni Jaeger Fine. She is assistant dean at Fordham University and also a professor at the same university in New York. She has many articles and books published, and I would say that two of them is well known. One is the American Legal System, a resource and reference guide, and the other one is Becoming a Lawyer, Discovering and Defining Your Professional Persona. So this is an honor for us, Professor Toni, to host you here. It's our privilege to hear from you. So the floor is yours.
Thank you so much, Professor Rodrigo. Thank you, Professor João. Rodrigo, I've just met you a few moments ago, but João, you and I met in New York some time ago, and we've remained in touch. And I want to thank you for, both of you, for hosting me and others on the webinar, and others for watching on YouTube. As I mentioned to Rodrigo and João in advance, I never thought that I would be a YouTube sensation, so I look forward to that. I'm going to share my screen now and share with you the PowerPoint presentation that I've prepared for today's lecture. And again, it's a great honor and a great privilege for me to be with all of you. And I'm going to give you an introduction to civil procedure in the United States. And my hope is that as you listen to me talk about different elements of the civil procedure process in the US, you may find some things that are similar to the way it's done in Brazil. You will find certainly many things that are different, and that we can have a conversation perhaps later or in the future. I've given you my email address about why we have different structures, why we have different systems, which system works best, or some of the differences a result of criminal law versus civil law jurisdictions, so on and so forth. So I hope that this overview will be interesting for you. The topics I want to touch upon are first introducing the basic forms of dispute resolution, the players in civil litigation in the US, and this will be a little bit different from what you're used to in Brazil, a few other introductory matters, and then I want to discuss sort of an overview of how civil litigation works from the pretrial to the trial to the appeals processes. And this is not obviously comprehensive, but I do hope that it's enough to spark your interest in learning more about certain of these aspects. And so obviously litigation is a very common form of dispute resolution in the US. I'm going to focus on that for much of today. In the US, we are known as a very litigious society. We sue people all the time. But at the same time, we also settle a great deal of our cases. So the figure is probably upwards of 90 and probably even perhaps above 95% of the number of cases, civil cases that end up being settled by the parties themselves. And so although we are litigious, most cases do not end up at the trial stage. They settle, they are resolved sometime earlier than that. We also make very wide use of different forms of alternative dispute resolution mechanisms, especially arbitration and mediation. I know that you also make great use of arbitration and mediation and perhaps other forms of alternative dispute resolution mechanisms in Brazil, but it would be incomplete for me to talk about litigation without mentioning that we do make very, very broad use of these mechanisms as well. I want to say a couple of things about the parties to litigation in the United States, because here is where we start to see some of the divergence between the Brazilian/civil law system and the U.S. common law system. First, we have what's known as an adversarial system. And in the adversarial system, which is distinguished from the inquisitorial system that is common in civil law countries, the parties, through their attorneys, are really primarily responsible for pretty much everything that goes on throughout the process of civil litigation. And I'll point this out in a couple of specific places along the way. But for example, the parties do all the framing of the legal issues. The parties do all the fact investigation. The parties make motions when they want the judge to do something. The judge at the trial level in the United States is relatively passive. The judge will decide questions of law, but the judge is absent from the process of framing the legal issues, of factual discovery. The judge is pretty much entirely absent from that process. We'll talk a little bit about it later. And the jury, of course, is perhaps the most bizarre element, or one of the most bizarre elements for people like you coming from Brazil when they learn about our system. The job of the jury is to decide questions of fact, while the judge is responsible for deciding questions of law. And the jury is not just sort of a strange whim that we have in the United States. The jury is actually a constitutional mandate in most civil and most criminal cases. So we could debate the merits and the drawbacks of the jury system, but it is really deeply embedded in our constitutional system and in our concept of rule of law. So it's something that we could certainly debate about whether it's a good idea or a bad idea, what are its advantages and disadvantages, but is very much a cultural institution that is protected by the Constitution. I want to make just a couple of other introductory remarks, because I think it's important to say these in contrast to what you may be familiar with from your system. And the first is that court fees in the United States are not a big deal. I know that I don't know specifically about Brazil, but I know that in many civil law jurisdictions, the court fees can be quite high, as they are often tied to the amount of damages that the plaintiff is seeking. In the United States, the court fees are set and they do not change based on the value of a particular case, and they are not very high. So if there's one thing that's a bargain in the US, it may be court fees. Court fees are just not a big deal. Excuse me, I was explaining earlier that I have a little bit of a cold, so you're going to see me cough a little bit, and I apologize if my voice is a little funny. Second, in the United States, a plaintiff can seek punitive damages. Punitive damages, the word punitive comes from the same word as punish. They are damages that go beyond compensatory damages and are intended to punish a wrongdoer. And they're not available in every case, but they're available typically in cases in which the defendant has acted with some sort of willful disregard or intent, and typically in which the plaintiff either was killed or seriously physically injured. So cases, for example, the classic case of punitive damages was when the cigarette producers and manufacturers and sellers deliberately withheld information about the harmful effects of tobacco and nicotine, and also about the addictive nature of the nicotine. And so those cases were cases that were ripe for punitive damages. These are very controversial in the United States, as I know they are in many other places, but we do have the availability of punitive damages in certain kinds of cases. The final sort of introductory remark I want to say is that rules of procedure and evidence in the United States are jurisdiction specific. So we have a set of federal courts, and in the federal courts, we have a set of rules of civil procedure and a set of federal rules of evidence. But in each of the 50 states, we also have individual state rules on civil procedure and on evidence. And I believe that although Brazil is also a federalist system as the US is, I believe that you have more consistency, more commonality among the rules of evidence and procedure among your states. And so that is very different in the United States. So the rules of civil procedure, the rules of evidence, for that matter, jurisdictional rules, how judges are selected, their tenure, all of these things will be different among the different states. For purposes of clarity and because I personally find it more interesting, the rest of my discussion will be based on the federal rules of civil procedure, to some extent the federal rules of evidence. If you're ever working or interested in a particular state rules or system, you would need to research that particular state law. Having said that, there are many, many commonalities among the federal system or between the federal system and some state systems, but be careful, you need to be cautious as significant differences sometimes exist. So let's start with what happens at litigation. And this is sort of a sort of roadmap of how you get through a U.S. civil litigation. It begins with the plaintiff's complaint, which we'll talk about in a moment. The defendant then responds with either an answer or a motion to dismiss. We typically then have pretrial conferences followed by discovery. And if I had to say the other thing that really mystifies people from outside the U.S. when they learn about our civil dispute resolution system, first it's the jury system that's confounding, and then the discovery system is very, very broad, very invasive, very expensive, very time-consuming. So we'll talk a little bit about the discovery system in the U.S., followed by some pretrial motions, followed by the process of trial and appeals, okay? And obviously, we'll just be speaking a little bit about each of these topics. So the complaint is what begins the litigation. This is filed by the plaintiff, and the elements of the complaint are the following. First, the complaint will set out the parties, sort of the names and the residences of the parties, the nature of the party, if it's a corporate entity or partnership, the basis or bases for jurisdiction and venue. So jurisdiction refers to the split in authority between the federal courts and the state courts. The federal courts can hear some kinds of cases, the state courts can hear other kinds of cases, and so a complaint must always set forth the basis for jurisdiction in the federal court, for jurisdiction also over the particular defendant, and venue. Venue, the word venue means place. And so it indicates why the court proceeding is properly brought in this specific court. It will also outline the facts. And by the way, the complaint will be based on a number of numbered paragraphs, sequentially numbered paragraphs. And each numbered paragraph should contain only a single allegation. So the facts will be set up in, one after another in separately numbered paragraphs. It will then establish the claim or cause of action. Sometimes there are multiple claims or causes of action. There will be a demand for a jury. If the plaintiff wants a jury, the right to a jury can be waived. And so in order to preserve the right to a jury, the plaintiff will ordinarily demand a jury trial in the complaint. And then there will be something called a prayer for relief. This is a very archaic term that we use. It's a request for the relief that the plaintiff wants. So the plaintiff may ask the court to issue, to award X number of dollars in compensatory damages, and then perhaps X number of dollars in punitive damages, and so on and so forth. The prayer for relief can also include a request for some forms of equitable relief, such as please enjoin, please prohibit the defendant from engaging in this kind of behavior in the future. The complaint is accompanied by something called a certificate of service, which is the lawyer's affirmation that she has served this complaint on the defendant. And I think this may also be different from the practice in Brazil. I know it's true in many other civil law countries where the court is responsible for the service of the complaint. In the United States, that is done by the parties, another way in which our system is adversarial and involves the actual effort by the lawyer. It will also be accompanied by a summons. And a summons is an order issued by the court at the time a complaint is filed that requires the defendant to respond by a certain date. And that response can either be an answer. And an answer is a typical response. It is a paragraph by paragraph response to the allegations in the plaintiff's complaint. And the defendant can do one of three things. The defendant can admit the allegations in a particular paragraph in the complaint, or the defendant can deny the allegations in a particular paragraph in the complaint, or the defendant can say that she has insufficient information to either admit or deny. And with this admission of certain allegations in the complaint, already the legal issues, the matters that are left open for trial begin to narrow a bit through this process of admitting and denying. An answer may include a counterclaim or a cross-claim. A counterclaim is a claim that the defendant makes against the original plaintiff, and a cross-claim is a claim that a defendant may make against another defendant. So it's something like, well, we didn't do it, but if we did, it was his fault, okay? It was the other defendant's fault. Instead of an answer, the defendant can file what's called a motion to dismiss. And this is governed by Rule 12B of the Federal Rules of Civil Procedure. And I'm not going to mention too many rules, maybe 2 or 3. Why? Because this is something that you sometimes hear people talk about, a 12B motion. Rather than calling it a motion to dismiss, sometimes the rule's name is used to indicate the substance of the motion. So a motion to dismiss essentially is a motion that a defendant can make very, very early on in the case, alleging that there is some reason, some legal reason why the case should be dismissed now. We don't need to look at the facts. We don't need to dig deeper into the matter. There is some legal infirmity in the case, in the complaint, that justifies dismissing the claim right away. This can be lack of subject matter jurisdiction. The federal courts are not empowered to hear this case. It can be lack of personal jurisdiction. The federal courts do not have this court does not have the authority to compel the presence of an out-of-state defendant in this state. That the venue is improper, that the process or the service of process was insufficient, that there was failure to join a necessary party, or the big, most important, most compelling of the motions to dismiss is what's called a motion to dismiss for failure to state a claim upon which relief can be granted. And this is an incredibly important device. It basically says this. The defendant claims that the plaintiff's complaint, regardless of whether the facts are true or could be proven, the facts as alleged by the plaintiff are not sufficient to give rise to a claim upon which relief could be granted by the court. And so it is not the court making a decision that the plaintiff alleged facts that are not true. We assume all the facts as alleged are true, but still, those facts as alleged do not give rise to a claim upon which relief could be granted by a court. So that is really the most substantive of the motions to dismiss. Follow it. Now, let me just go back for a moment. If a motion to dismiss is granted in its entirety, then the case is over, okay? If the motion is granted in part, then we still have to go back to a claim. And we just go back to, if the motion is denied in its entirety, then the defendant will have to submit an answer. And then we go back on track, and the next stage will be pretrial conferences. And these are held by the judge. My guess is that right now they're being held remotely. I think even before COVID, judges were starting to realize that there was no need to make people come down to the courthouse, and you could do it through Zoom or through video conference or webinars or something like that. The purpose is are first to expedite the disposition of the case. For the judge to indicate that she expects this trial to move along and the parties should not drag their heels. To establish what, in the words of the rules of civil procedure, are an early and continuing control over the case to manage and avoid protraction. And this is important because until relatively recently, I would say the last 15 or 20 years, 15 or 20 years ago, before that time, judges took a very, very passive role also to expediting cases before them and to managing the litigation. And the view of the judiciary in general, obviously there were exceptions, the view of the judiciary was pretty much, if the parties are not in a hurry to complete this case, we don't need to rush them. We don't care. We'll just have it sit on the docket for years and years and years. Now, judges are taking a more affirmative role in getting cases disposed of quickly, understanding that there is a public interest in getting cases resolved. The judge will also signal that she will not allow wasteful pretrial activities, keep things moving, and in the words again of the Federal Rule of Civil Procedure, to improve the quality of the trial through more thorough preparation. So pretrial conferences have become opportunities for the judge to sort of set the tone and set the pace for the remainder of the claim. The judge at this time will also issue scheduling deadlines for joining parties, bringing in other parties, for amending the pleadings, for completing discovery. And discovery, as we'll talk about in a few moments, often takes years and years and years, and to file motions in advance of the trial. And then the judge typically will memorialize the actions taken in a pretrial order. Very often the court will say to the parties, will you write up the motion, you agree to what you think you heard, and I'll take a look at it and then sign it. Now discovery begins. And discovery, again, is this sort of very, very time-consuming, very intrusive, very expensive phase of civil litigation in the United States. It is compulsory that disclosure be made of information at the request of a party. And the scope of discovery is very, very broad. You can discover anything that is, and I'm quoting the language now from a rule, reasonably calculated to lead to the discovery of admissible evidence. So it's not just that a party can discover admissible evidence, but anything reasonably calculated to lead to the discovery of admissible evidence. And so the scope and the nature are extraordinarily broad. There are 5 recognized methods of discovery, and I'll just tell you a few things about each one. Interrogatories are written questions seeking written answers. The number of interrogatories you can file against another party are now limited. It used to be, when I practiced law many, many years ago, there were no limits to the number of questions you could ask through the interrogatory process. And that led, frankly, to a tendency towards abusing the discovery process. Requests for production are requests that one party make to another party that the party produces something, usually documents, or in today's world, electronic versions of documents, but it could also be a thing. So if there's a case involving a product, a particular product, it could be that the product is actually requested to be produced by the party. Depositions are oral questions seeking oral answers, and this is typically done not in the court, in the courthouse, but at the office of one of the attorneys. A witness is there. There will be a court stenographer who's transcribing the information that is indicated by the witness. The lawyers will be present, and depositions are very often used to find out sort of who knows what in the organization and who does what in the organization, and how do processes work. If this person had written a memo to somebody else, what would have happened next? Who would have filed it? Who would also it have been sent to? Who would have been at certain kinds of meetings, and so on and so forth. Although they can be used for any broader purpose. Depositions can be used at trial first to contradict the testimony that someone makes at a trial. So if I'm a witness at a trial and I say something and the reviewing party doesn't like it, that party can say, do you remember having your deposition taken in my office 6 years ago? I remember that. Yes. Do you remember saying this? And they'll put the transcript in front of me and they'll ask me to read from the transcript. And they'll say, well, explain the inconsistency. Do you remember better now, 7 years later, or did you remember better then? Did you lie then, or are you lying now? Depositions may also be used if a witness ends up being unavailable for trial. So if you have an important witness who is outside the jurisdiction or who is likely to be out of the jurisdiction or who is otherwise likely to be unavailable. For example, you have a 90-year-old witness who's really, really important. Very often you might videotape that to have it to show at trial. Requests for admission are requests that set forth certain factual allegations and ask the other party to admit the allegations, to deny the allegations, or again, just like with the answer, to say, we just don't know. The difference between the allegations in a complaint and the allegations in a request for admission is that if the party knew or should have known to admit certain allegations in a request for admission, they will be charged with the expenses of the other side in proving those facts at trial. And finally, you can ask for a physical or mental evaluation of a party. This is only when physical or mental evaluation would be relevant to the issue. So you cannot use it to harass, where you say to someone, what are you, crazy? I want to get a mental evaluation. But if the physical or mental state of mind or state of body is at issue in the case, then you can certainly have that person undergo a physical or mental evaluation. Discovery is exceptionally broad, but there are a few privileges, a few areas where the other side may not intrude. And so there are two categories of privileges from discovery. The first is called attorney-client confidential communication. Any communication between privileged persons, so I'm talking about attorney-clients here, it could also be priest and penitent, it could be doctor and patient, and so on and so forth, but the attorney-client confidential communication is the one that comes up most frequently, a communication between privileged persons made in confidence, in private, there couldn't be other people around, for the purpose of seeking, obtaining, or providing legal advice, are confidential and may not be discovered. And this is an absolute bar on discovery. One of the things that clients used to try to do that doesn't work at all is they would, and so this last element is very important, they would write basically a business memo or a business letter, and then they would copy the lawyer at the bottom. That doesn't work. Just copying the lawyer does not put it under the attorney-client confidential communication. It has to be for the purpose of seeking, obtaining, or providing legal advice. And this privilege is basically a policy decision that we want people to be very open and forthright with their attorneys and not hold things back. So I know that if I have an issue, I can discuss it fully, and all the bad laundry can come out with my attorney, and my attorney can never reveal those communications to anybody else. The second privilege is known as attorney work product, and the elements here are tangible documents and tangible things that would be otherwise discoverable, that are prepared in anticipation of litigation by or for a party or that party's representative. And there are two kinds of work product, one of which is fully barred from discovery and the other of which may be discoverable. The first is mental impression work product. Mental impression work product is never, ever discoverable. What is mental impression work product? Well, let's imagine that I'm a practicing attorney and I have a client. The client comes to me and I work through the problem. I read the documents. I do the research, and I come up with a strategy for winning this litigation. Okay, it's in anticipation of litigation. And again, it's a matter of policy that it's a good thing for me to write down that strategy, because I could forget it by tomorrow. At my age, I could easily forget it by an hour from now. I could get hit by a car. I could leave the firm. And so it's important that a lawyer writes down the strategy, thoughts about how to pursue the particular litigation. Those will never be discoverable. There's other work products that may be discoverable if there is a substantial need on the part of the other party, and an inability to obtain that work product without undue hardship. So an example could be, and again, the party still has to make a showing of need. Let's imagine that I represent a very, very wealthy client, and that client is involved in litigation against an individual, and my wealthy corporate client hires one of the big four accounting firms to do some number crunching. It could be that I might have to reveal some of that to the other party if that party shows a substantial need. During discovery, there is very, very limited judicial recourse. The judge does not want to see you during the discovery phase. You can go to the judge as long with a couple of different requests that I'm going to explain in a moment, as long as the parties have made a genuinely good faith effort to work through their issues together. Because the judge, when you do go to the judge on a discovery matter, the judge will be very, very distressed if you haven't even written to the other side to try to fix the problem. Sorry, I lost my pages. And so you're going to have to make a really, really good faith effort to have worked through the issue with your opposing counsel. So the first thing you could seek is a protective order. A motion for a protective order asks the court to either limit the kind of discovery that you're receiving or that you need to respond to, or to make certain exceptions from discovery. And a really, really common request for a protective order would be, let's say I'm the receiving party of discovery, and the discovery is seeking either a trade secret, okay, the Coca-Cola recipe, okay, some sort of trade secret, some sort of confidential, sensitive internal information. For example, employee information. They want a list of all my employees and how much I pay them. I'm not going to do that. Now, if the lawsuit is legitimate, let's say it's a gender discrimination in the workplace lawsuit, I could say, okay, I'll give you that information and I'll indicate whether the particular employee is a man or a woman, but I'm not going to give their names. I'm going to excise certain information, and the court may order that that is acceptable. A motion to compel is sort of the flip side, where let's say I'm the party seeking discovery from the other side, and the other party is not responding or not responding in a meaningful way. Then I will ask the court, please tell them that it's their obligation to respond to these very legitimate discovery requests. But again, the judge is primarily out of the business of discovery. And if you do go to the judge on a discovery matter, you really have to make sure that you have covered all your bases and worked really hard and created a paper record of trying to work it out with the other party. The next thing that happens is a series of pre-trial motions, the most important of which, by far, is summary judgment. And this is another rule that we often refer to by its number. So rather than summary judgment, sometimes we say, I'm working on a Rule 56 motion. A Rule 56 motion is similar to a motion to dismiss in the sense that the party who files the motion is trying to get part or all of the case dismissed. But it's very different from a motion to dismiss in that at this point in the proceeding, there is a factual record that's been established during that whole discovery phase that we just talked about. It is essentially asking the court to dismiss the claim on the basis that under the facts presented, no reasonable jury could find in favor of the non-moving party. So let me give you an example. If I were to, let's say that I am teaching a class one night at Fordham Law School, and there are a number of students, and one student sues me the following day, and he says, you tripped me deliberately on my way out of the classroom, and I fell and I hit my head in a concrete wall, and I had a concussion, and I was bleeding, and I lost my job, and I had to delay my studies, and my girlfriend broke up with me, and all these terrible things happened. And I say, wow, this this is horrible. I can't believe I'm being sued by a student. I'd love to be able to file a motion to dismiss, but the truth is, unless there is some legal infirmity with the jurisdiction or the summons or the way the process was made or the court in which he filed the case, I don't have a good motion to dismiss, but I might have a good motion for summary judgment. So let's imagine that I ask in discovery, I ask the plaintiff to please supply me with police reports, security reports, photographs, medical reports, employment reports, witness statements, and he produces nothing. I, on the other hand, have 20 witnesses in my class, and they all wrote affidavits, and those affidavits say, that is ridiculous. Toni did not trip Bob on the way out of the classroom. In fact, we all went out with Bob that night. We were there having drinks with him. He looked totally fine. He was in class the next day. We've seen him with his girlfriend. I have 20 affidavits. He has proved absolutely nothing. The court will grant summary judgment because the moving party, I have shown that there is no genuine dispute as to any material fact. It's a genuine dispute. And so the role of the judge here is not to find facts. We know that the judge can't do that in our system. That's the role of the jury. But what the judge determines is whether, as a matter of law, there are sufficient facts upon which a jury could find in favor of the non-moving party. So summary judgment is a very, very important mechanism. There are other pretrial motions that could be made. A motion really just is the word to refer to a request, formal request made to the court to do anything. It could be to start one day later because I have to go to the dentist, or to, it could be anything. A motion in limine, though, is another really important pretrial motion. And this is a motion that asks the judge to exclude as inadmissible in advance of trial certain evidence or certain information. And this is a kind of motion that only needs to be made in a jury trial. Why? Because we worry that the jury, once they hear something, may be biased. And so even if the question is not answered at the trial, just asking the question may be enough for a jury to be biased. So in this case, we ask the judge in advance to exclude certain evidence or certain topics from being raised at trial at all. And we're now at the point where the trial begins. And these are the various stages of the jury trial. Jury selection, followed by opening statements, followed by the presentation of proof, followed by the jury instructions, followed by the verdict. The jury selection is, I assume, something that is completely unfamiliar to most of you because you have either, I'm not sure if you have jury systems and a jury in some kinds of maybe homicide cases, but I know that the jury is not something that you see very often in Brazil. We call the process of jury selection voir dire, to tell the truth. And the first stage is the screening of potential jurors. So potential jurors are screened for their basic eligibility to serve. Are you old enough to serve? Are you a citizen of the United States? Do you live in the right jurisdiction? Do you speak English well enough to understand and participate in the proceedings? Are you physically and mentally fit in order to serve? Are you a convicted felon? Because in many states, convicted felons are not eligible to serve for jury service. I don't agree with that, but it is the rule in many, many states. Then the next phase is where the lawyers or the judge question the potential jurors. They question the potential jurors about this particular case. And the goal is to assess the ability of each prospective juror to decide the case on the basis of the facts presented and not bias or prejudice. So when you think of really, famous press-worthy cases like the Michael Jackson trial, they had to find enough people to sit on that jury who had not decided whether Michael Jackson was guilty of sexual impropriety. Okay, That's pretty hard to do when every newspaper and every television station every day is reporting on the Michael Jackson issue. And so what happens is the lawyers will decide whether they want to challenge anybody that's sitting in the room. And there are two ways you could challenge prospective jurors. One is for cause, okay? And that is some concern about the jurors' neutrality because of some verifiable fact. So let's imagine, I don't know, the case involved some guy who lost an arm in in a work accident, okay, and he's lost his arm. And there's someone in the jury pool who's sitting there without an arm. And you say, what happened to your arm? Well, I lost it in a work accident. Out you go, okay? It is understood. It's nothing personal against that prospective juror. It is understood that he will have some special feelings that will make it difficult for him to be completely unbiased. As many challenges for cause as you need to go through, you go through. It could be that, oh, I know the judge, okay, I'm going to be excused. I know one of the lawyers, I'm going to be excused. I know one of the parties to the case. I work for Fordham University as one of the parties to the case. Well, obviously, I can't sit on that case if my employer is a party. So there are all sorts of reasons why you could challenge a prospective juror for cause. There are also these things known as peremptory challenges. And this is a limited ability, usually one or two, to exclude jurors for some other reason. So I might say, you know, I see, if I were a trial lawyer, I see that person on the jury, and she seems very distracted, or she's asleep the whole time, or she seems to be fascinated by the lawyer for the other side. Okay, I don't want her. I can exclude her. I don't have to say why. There are certain limits, though. I cannot, for example, exclude her because of her race, depending on the jurisdiction, because of her religion, because of her national origin, because of her sexual identity. So there are some exclusions, but in general, there is some limited ability by the lawyer to exclude one or two people just because that lawyer doesn't want that person on the jury. The next thing that happens is opening statements. And opening statements is, and by the way, when you see a court scene in a U.S. movie or television show, it's almost always a trial court, right? Because that's where the action is. That's what's fun. And so you've seen opening statements probably. These are each party's summary of the story. It's an overview of what is to come to help orient the jury towards what they're going to hear from various witnesses, because the actual presentation of evidence is a little bit disjointed. And so I would get up there if I were a lawyer for the plaintiff, and I would explain the witnesses that I was going to present and what they would show. Now, the summary, this opening statement is not evidence in itself, and the jury is not supposed to consider it as evidence, but it does give the jury context for understanding what comes next. And if I've done a good job in my opening statement, when I sit down, the jurors should all be saying, of course her client wins. This is obvious. So the goals are to, again, help guide the jury through the evidence to be presented, but also to predispose the jury to my side of the story. Now there's the presentation of proof. And again, you've all seen this on TV, in the movies. The goals are two interrelated goals. First, to build up one's own case, and second, to tear down your opponent's case. The types of evidence that can be produced is everything from testimonial evidence, witnesses testifying to what happened, what they saw, what occurred, to real evidence. This phone is an issue. My iPhone exploded. We're actually going to bring the phone in to see what happened. Demonstrative evidence. Demonstrative evidence is evidence that purports to represent something else. It could be anything from a photograph to a diagram to a map, anything that purports to represent something that's relevant in the case. And finally, writing, documents, okay? Documents that will be generally sometimes shared with the jury and sometimes just read into the evidence for the jury to hear. The party with the burden of proof will go first. That will be the plaintiff or the prosecutor in a criminal case. The defendant will go next, and depending on the jurisdiction, the plaintiff or the prosecutor sometimes has the final word with respect to these closing statements, okay? Closing statements is the mirror of the opening statements. Again, they are not proof, but they draw together what the jury heard. Because that presentation of evidence is very, very disjointed. You have one witness who testifies to this, but it's very rare that you could present a case in a way in which one witness flows from the other. You have to draw all that together in an intelligible manner. And of course, the principal goal of the closing statement, when I sit down for my closing statement, the jury should be convinced that my client wins the case. The next is going to be, again, very strange for you guys because it involves the jury. The jury is instructed in something called the charge. The judge provides the charge to the jury. This is the judge's instruction on the law. The jury will take that instruction on the law and sort of fill in the facts as it found them to be. The goals of the charge are to explain the substantive law. Okay, there are three elements to finding a defendant negligent. You must find this, you must find this, you must find this. The charge will also allocate and define the burdens of proof. Who has the burden of proof and by how much? What does it mean beyond a reasonable doubt? What does it mean by a preponderance of the evidence? The judge's charge will also include admonitions about the way in which the deliberations should be conducted. You may or may not speak to people outside of the jury room. You may or may not watch TV. You may or may not discuss this individually. Usually the jury needs to discuss the case only when all of the jurors are present, and perhaps some instructions on evidentiary matters. It may be that there was certain evidence. Can you still hear me? I feel like I lost my connection.
We do hear you just fine.
Okay, I lost my video connection. I'm trying to get it back. I apologize, but I'll speak while I can and hope that I can reconnect in a moment. So bear with me, please. I'm going to try turning my Wi-Fi off and turning it back on. Maybe. I'm trying to get back in the Zoom room now. Please accept my apologies.
No problem.
It's working to connect, and I hope it connects quickly. Yeah, I did. Password. Oh, wait. Okay. Oh, sorry. Somebody's letting me in. Can you see and hear me now?
Yes, we can.
Okay, I'm so sorry about that. Go back to my shared screen. It may be that the jury heard certain things that were ultimately excluded from evidence, and so the judge will say, do not consider the information that you heard. It may say that you should decide certain points in your deliberation before other points. It may say that you can consider certain evidence of proof of one point, but not of another. So these will be the principal goals of the charge that the judge makes to the jury. The jury will then deliberate under whatever conditions the judge established, and then will come back and deliver the verdict in open court. It's different in different courts. In some circumstances, the jury foreperson hands the written verdict to the judge or the clerk. Sometimes the judge or the clerk reads the verdict. Sometimes the jury foreperson reads the verdict into the record. I have to say that I am fascinated by the jury system, and I've been called for jury service, of course, many times, but I've never actually sat on a jury. And I would actually really love to see better what happens in the jury room and how the process works. It's also a very especially in very, very significant cases involving a lot of money, but especially in criminal cases. It's a very weighty responsibility for an ordinary citizen like myself to have. So someday I hope I can come back and I've had that experience and I can tell you about it. On appeal, let me just say this, that you have the right to appeal in the federal system from the district court, which is the trial level court, to the Court of Appeals, which is the intermediate level, intermediate appellate court in the same circuit. And because I'm sure that you don't know how our districts and circuits are organized, I show you this map. What you see here are a lot of white numbers with black circles around it. Those represent different circuits. And in each circuit, there is an individual, a single Court of Appeals, plus some number of district courts. So it's easiest to look at the West Coast states because they're so large. So if you look at this green region here on the western coast of the United States, you see that this is a region that contains the US Court of Appeals for the Ninth Circuit, plus all the district courts that fall within that jurisdiction. When you appeal, for example, from the Northern District of California, that's the trial court in the northern area of California, you must appeal to the Ninth Circuit Court of Appeals. You can't decide that you want to come to the Seventh Circuit. You must appeal within that circuit. There is something known as the final judgment rule that is at play in our federal system, but not, for example, in New York. In New York, there's a very different rule. The final judgment rule limits your appeals to the end of the case. So there are very, very few things that you can appeal along the way on an interlocutory basis. For most claims, you have to wait. You have to preserve the concern by objecting before the trial court judge, but then you don't appeal right away. You have to wait, and you bring all of your concerns up on appeal at the end. Another limit on appeal is that the court will only consider legal issues. Why? Because the facts as decided by the jury must, for the most part, almost always be respected. That's the only way to respect the constitutional promise and requirement of a right to a jury trial. So on appeal, for example, you can argue that the judge made a mistake in the charge. You could argue that the judge admitted certain evidence that she should not have admitted. But what you cannot argue on appeal is that the jury was a bunch of idiots, okay? You could say that there was a deficit with respect to the constellation of the jury, that putting the jury together suffered from some legal flaw, but you can't say the jury didn't understand the case, they were too stupid, they got the facts wrong. That is not an appropriate issue for appeal. On appeal, the record that a court can consider will only include issues that were properly preserved below. So again, you must object before the trial court judge in order to preserve that error for appeal, and there will be no new facts presented on appeal. You are stuck with that record that was established at the lower court. There's something known as the standard of review on appeal. And what this means is that the appellate court, I have no idea how this works in Brazil or in other civil law jurisdictions. On appeal, the court will not reverse for something called harmless error. So let me give you an example of harmless error. Let's imagine that it's a criminal case and there are 50 witnesses against the defendant, okay? 50 witnesses that say, I saw the guy, that was him, he did it. And one of those witnesses, it turns out, had a conflict of interest and probably shouldn't have testified. And the court would say, okay, yeah, that one witness should not have testified, but it doesn't matter. We have 49 other witnesses. There was no substantial effect on the outcome because of that error that was harmless error. Finally, the trial court decision normally will go into effect unless the defendant requests a stay pending appeal. So let's say that someone gets a verdict against me for $1 million. That person can begin to enforce that judgment immediately unless I request a stay, a delay of the implementation of that judgment until the appellate court has reviewed. And typically those stays are granted. The court might require that I put that $1 million in an escrow fund or something else safe so that I don't flee the jurisdiction or spend it all on, I don't know what I would spend $1 million on, but spend it. And so there might be some restriction on that money, but they will typically stay or delay the enforcement of the judgment. That's all I want to say for now. There is this book that I wrote that was translated into Portuguese some time ago by Martins Fontes. If you're interested in learning more about the US legal system, you could consider that. Rodrigo was kind enough to mention some other books that I wrote earlier on in the webinar. And if it's okay, I'll stop my share now, or would you prefer that I keep this slide up?
You could stop sharing your screen and
I will
okay.
Stop the share and come back to see all of you.
Thank you very much, Toni, for the lecture. It was great, fantastic, actually. All information here for us. Many of them are pretty new for most of us, so it's fantastic. And right now, I'd like to introduce João Lessa, that is a colleague of us, member of the Ceapro. And well, João is a professor at the post-graduation course at PUC, COGEAE, and PhD at USP. And so, João, please make your comments or questions. Feel free.
Thank you so much, Rodrigo. First of all, I want to thank you again, and also Ceapro for the opportunity to be here to discuss with Toni. Toni, thank you so much for being with us once more. I want to say that for sharing your knowledge, for discussing. It's such an overview of the US judicial civil system. It was a great overview, and I learned a lot. Thank you for that. We have, of course, because we see in the movies all the time things about the American way of litigation and the American process, and it seems to be all very theatrical. The lawyers, the parties presenting the case, the jury. And in addition to that, what we hear in Brazil are the very broad lines of common law, whatever that is. So we tend to have a lot of pre-comprehensions on a topic that we know little of. But there are a few issues that I would like to hear more from you concerning what you just said. And the first of those issues, the first one is the scope of discovery. Because discovery in the US tends to be much broader than in other countries, especially civil law countries. And I do understand that this has to do also to how well defined the case is in its beginning with the pleading process. And now there is a trend towards fact pleading rather than just a very general notice pleading. So if you could explain to us a bit more on why discovery is so broad and how this relates to the issue of pleadings and how things start on litigation, really, I think would be of much interest.
Thank you, João. That's a great question. Let me talk a little bit first about the scope of discovery. And when people hear about US-style discovery, they think it's insane, and it's way too broad, and it's got great potential for abuse. And all that is true. And it is very time consuming. It's very intrusive for the parties. It's very expensive. So let me just sort of balance these sort of obvious concerns about discovery, which are very clearly drawbacks to our system of discovery, by explaining a little bit about why we have such broad discovery. And so I think a lot of the reason for broad discovery like many other things in our system of civil procedure, is tied to the presence of the jury. And so it can't be, for example, one of the things about the trial, one of the many things about the trial that's motivated by the presence of the jury, for example, is the fact that the trial is a single event. And when it begins, it goes until it's over. Now, if it's a long trial, maybe there'll be a day off, maybe there'll be a break if the judge has something else she has to do, but it's an integrated single event. And I understand that in other countries, you may begin the trial, then you may have a break for a few weeks or months or so, and then come back. That cannot happen in the US because if for no other reason, because of the presence of the jury. And so the discovery process is also faithful to the adversarial system where the parties just sort of go at it. And it's faithful to the jury system because you have to have, we have an expression, have all your ducks in a row before the trial begins. The good thing about the discovery system, recognizing all its deficits, and I was a litigator, when I practiced law, I was a litigator. So I engaged in a lot of discovery and I saw firsthand how abusive it could be, how expensive it could get, how boring it is for a young associate to spend months and months and months on discovery. But it does enable parties to have a really good sense of the strengths and the weaknesses of their case before they go to trial. What's so good about that? Well, there's two things that are good about that. One is you can make more rational and reasonable settlement offers earlier. And that's always good, right? So it's always the case, I think, with lawyers that when you start a case, you get a case and you think your client has the greatest case in the world and your client is right and your client should be compensated. And then when you dig a little deeper, you realize that there is, with every story, a second side of the story. And so the process of pretrial discovery does allow you to see that other side of the story in enough time to hopefully make rational settlement decisions. It also allows you to prepare very, very well in advance of trial so that the trial can be efficient. And the trial simply must be efficient because the jury is sitting there. So once we impanel a jury, the jury is sitting there waiting to go, and you keep them there until the trial's over. So it wouldn't be where you have the trial, you start, and then you say, okay, we're going to recess for 3 weeks, come back. The jury is impaneled, and you have to go from beginning to end. So I think that in part explains the very, very broad scope of discovery. And I think it is also very closely tied to our adversarial system, which is the adversary should have all the information they need to have in order to prosecute the case zealously and effectively. It's a very interesting concept, João, that you tied it to the trend, which is absolutely correct. For those of you who don't have as much background, we still do have something called notice pleading. Notice pleading is alive and well. Notice pleading was a shift from earlier litigation rules that were very, very strict. And if you made some little technical error in the complaint, your case could be dismissed with prejudice, and that would be that. Then we had this sort of notice pleading where all you had to do was allege sufficient facts to put the defendant on notice of what on earth were you talking about? What is this complaint about? And now the Supreme Court is shifting us a little bit closer to something that is a little more fact-based. But until you asked the question, João, I hadn't really thought about the connection between more fact-based pleading or movement in that direction and discovery. And I think what it maybe means is if we do continue to move towards more fact-based pleading, lawyers and their party and their clients just need to do a little bit more due diligence, maybe in advance of filing a complaint. I think that's, to a point, that's a good thing, right? We shouldn't be just filing irresponsibly without doing due diligence. And so I think that's what it will do. I'm not sure it will change much in the way of discovery, other than to say that maybe you discovered a little bit more in advance. But I think that discovery will still remain extremely broad and extremely irritating to most people.
Fantastic. The point I singled that out is because in the Brazilian system of litigation, the parties, they need to present their facts on the beginning of the case, and then they need to prove their allegations. So the very first thing you do as a plaintiff is to tell your story, and that's it. You cannot really amend that at a later stage unless it's related to a new fact or something that you were not aware before. So in a way, the whole way of how evidence is discovered in Brazil and how things proceed has all to do with how you described your case in the first instance and not how you presented it after gathering evidence. So that's something I thought interesting.
That strikes me as a very difficult challenge for a litigator, right? To be able to figure out the story before they even really know the full set of facts. So that's a real challenge that you have that is much less challenging for us, I think. Very interesting. I didn't know that, João, but that's very useful.
Absolutely. And also in these views, still looking to discovery, we hear a lot in Brazil about case management and the judge's influence on, well, the pretrial proceedings. And it's my understanding that it's going towards a more active judge than it used to be in the past. And I hear that both for the US and for the UK. But again, the general view we have of common law is of passive judge, just that they will be basically waiting for the parties to get done with discovery or disclosure, and then they will take the case on at a later stage. How is the impact of case management in the US now in the federal courts? Is this changing the reality of discovery anyhow?
Yeah, that's a great question too. And I didn't know that was also happening in the UK. So I'm happy to know that. Somehow I know relatively little about, I probably know more about the Brazilian system than I do about the UK system, because I have so many Brazilian friends and colleagues, which seems very, very bizarre. So managerial judging, I would say a couple of things. One is that federal judges and state judges as well, and this is perhaps true in Brazil, judges in the US are very prestigious. It's a very, very prestigious position. And federal judges in particular, and probably the high court judges on certain state courts as well, are very, very, very esteemed. And so when you think about, I don't know the figures in Brazil, but we have fewer than 1,000 federal judges, which is, I think our countries are pretty much the same size in terms of geography and maybe even population. It's not that many. And so I think that gives you a sense of how prestigious it is to be a federal judge. And this is my way of saying that federal judges have a tremendous amount of flexibility and a tremendous amount of autonomy. And I think that if we had a panel with 3 federal judges here, if we got lucky, we would have one who was very hands-off, one who was a little bit more assertive with managerial judging, and one who was somewhere in the middle. I think that's probably the reality, that different judges have different approaches. And when I think of sort of the federal judges that I know a little bit personally, I'm thinking of 2 in particular. One, he's now in the Court of Appeals, but my guess is when he was on the district court, he was probably very, very permissive and very reluctant to be very forceful. And I think of this other judge I know, and I could imagine her just sort of beating people over the head. You're going to finish this within 2 years. You're going to finish this within 4 years. And so I think that there is a lot of variation. But at the same time, João, I think we're still very much an adversarial system where the judge is relatively passive. And I think what the judge tries to do in terms of managerial judging is pretty much, I would say there are a couple of things that he or she would do that are really meaningful. One is set a timeline. And the judge would still take into consideration. So she would say, so Toni, how long do you think you need to prepare for trial? João, how long do you think discovery is going to be? And I think most judges will take that into account simply because they don't have the information that they need at that stage to be able to make those judgments. Another thing that judges may do during that phase, which I think is, again, some of them are probably a little bit more assertive about this, is sending us to mediation, right? So they can't demand that we settle the case, but they could encourage us. And they could tell us, they could say, João, Toni, this is a stupid case. go to mediation, right? And then we're, okay, we probably should try again to settle this because the judge has already told us that she thinks the case is stupid. And so I think that still we very much have an adversarial system, very, very much, cabined a little bit by a little bit more judicial intervention, but I still think that it's very much a game that is run by the lawyers and their clients much more than by the judge.
Good. Also, your whole presentation was based on the federal system of civil procedure. And I think it would be helpful for our audience if you could single out which are the cases that go to federal courts. And I'm saying that because in Brazil, of course, we are a federative republic, but the cases in our federal courts are basically the cases that have to do with the union, with the Republic of Brazil as a part or interested in the case somehow. That's very different from the US system. So it's something that it's of interest.
Yeah, sure. And I actually wish I had added that to the presentation. That's a very, very good suggestion. So thank you for that. So there are a number of different ways to get into federal court in the United States. The first is whenever the United States is a party, and this sounds maybe a little bit like the Brazilian approach, when the US is a party, you can go to federal court. Second, when the underlying claim, the cause of action, is based on federal law, you can go to federal court. So that the claim, it could be based on US constitutional law. So let's say I claim that my First Amendment freedom of expression is denied by, you know, the New York City because I want to hold an anti-Trump protest and they won't let me do that. I could bring that into federal court. But also, in many of the cases that come to federal court are based on something on federal statutory law. So if the claim arises, let's say I say that somebody stole one of my books, translated to Portuguese, published it, copyright violation. Copyright law happens to be federal law in the US, so I could go to federal court. The third way is something that's going to strike you all as very bizarre. So let me explain it, and then I'll tell you why we have it. You'll probably still think it's bizarre, but maybe a little bit less so. It's called diversity jurisdiction. And in diversity jurisdiction, you have two requirements that must be met. One is that the parties be citizens of different US states or a US state in a foreign country. So a citizen of New York suing a citizen of New Jersey, or a citizen of New York suing a citizen of Brazil. And the amount in controversy is more than $75,000. You might be thinking, what? That makes no sense. Let me explain why we have it. Let's imagine that we have a citizen of New York suing a citizen of New Jersey for $1 million. We would, if there was no diversity jurisdiction, and it's a contract claim or a tort claim, it's not based on federal law. So by definition, diversity cases are based on state law. And we'd either end up in the New York State Court, in which case the defendant from New Jersey would say, I'm going to be treated unfairly. I don't want to be in a New York court. Or we end up in a New Jersey court, in which case I say, I'm going to be treated unfairly. I don't want to end up in a New Jersey court. So diversity jurisdiction, it doesn't really acknowledge that a state court will be biased. But what it does acknowledge is that an out-of-state defendant may be concerned about bias by an out-of-state court. And so in cases involving a significant amount of money, we allow those cases to come to federal court, even though they deal with state law matters. So those are the three primary forms of kinds of cases that come to the federal court. There are two, what I like to call variants or derivative forms of federal court subject matter jurisdiction. One is called supplemental jurisdiction. And this means the following. I'm in federal court, I'm a litigant, I'm in federal court under federal question jurisdiction. The court may exercise supplemental jurisdiction over a related state law claim. So here's an example. Let's say I get, so in the US, we have this employment at will doctrine where it's very easy to be fired, unfortunately for me. So let's say I sue my former employer. I was fired from my job. I sue my employer and I say my employer violated some federal law when they sued me, okay? And in addition, they breached the contract, okay? So I go to federal court under the federal question, federal law that was violated. The court has discretion to hear the related state law claim on the contract. The second derivative form of federal subject matter jurisdiction is called removal jurisdiction. Let's say I sue João for $1 million. João's a citizen of Brazil, I'm a citizen of New York, and I sue him in the New York State Court. I don't want to end up in the New York State Court. They're going to be biased against me. Because I'm the plaintiff and I have the initial choice of forum, the defendant can exercise removal. Very simple. All he says is the case originally could have been brought in federal court, but was brought in state court. I want to remove it to federal court, and that will happen automatically.
Fantastic. So it's actually very, very different and very peculiar, because in Brazil, the state courts, they deal with pretty much everything, and they do apply federal law on a regular basis. And actually state legislation is not as important as it is in the US, at least in day-to-day private matters in general. This is a major difference.
That's another thing that I did not know. So, you know, one of the things I love, I work mainly with international students, people like you who have studied law in a different, usually a civil law jurisdiction. And this is so illuminating for me because I learned so much about other systems, but it also forces me to question, you know, you assume a lot about the things you learn about your own system. Well, this is the way it works. And then you learn about a different way and you think, oh, why do our federal courts deal with so many different kinds of matters? And it really makes you question why we do the things we do and whether it's sensible to do the things we do.
It's true. This is one very interesting side of comparing legal systems and actually how things are done on day-to-day basis, because they sometimes differ a lot from statutes and regulations. But I also have a question to you. It's my understanding that less and less cases now, they are being tried in full, or they are being presented to juries. And this has to do maybe with expenses and costs in litigation, or well, discovery, maybe it's fulfilling another role. So I would like to hear you on that, because that's very interesting, because the whole system is taught to drive the case towards the hearing, but the hearings, they're not happening that often anymore. So
yes, we used to call it the shrinking jury trial, and now we call it the disappearing jury trial. And I don't have the statistics, but you're absolutely right. We don't see that many jury trials. And I think, João, you really put your finger on it. It's a confluence of many, many things. The presence of the jury trial, which around the whole system of civil procedure is based, right? And so we have to plan for this jury trial, right? It's all based around this, and yet it puts up these, I don't want to say roadblocks, but it creates certain disincentives. The cost is one, because of discovery, because of the way evidence has to be presented to a jury. You have to present it in a very different way than you would present it to a judge, right? A judge knows what she's doing. A judge is going to understand evidence in a different way than a jury will. It's also about things like punitive damages in certain kinds of claims. And it's also about lawyer fees. So one thing I should have mentioned, and this may be different in Brazil, is that in the US, we have what's called a no attorney fee shifting rule. And what that means is that I pay my lawyer, you pay your lawyer, and it's going to be very, very, very rare circumstances where the loser will have to pay the attorney fee of the winner. So let's imagine that I'm suing some guy named Bob, okay? And I think I have a really good case for getting $10 million out of him. But I know that's going to take 15 years. Do I want to pay my lawyers for 15 years, or do I want to take a $5 million settlement now and be done? I think that in many cases, we just decide, I want to be done. And I don't want to go through the whole drama of litigation, which essentially, you know, often after litigation, it gets so nasty and so divisive that, you know, our working relationship the adversaries find it very, very hard to work together again. So if this is a commercial relationship that I value, that's another thing that might go into that. So it's really about cost. I think it's about certainty in this uncertain world in which we live with. Would I rather have 5 million now or 10 million in 15 years? There's a lot to be said for taking the money and running and not letting my lawyers sort of eat up at the 5 million in that I might have lost.
Fantastic. Also, regarding the jury, you did single out some specifics on the selection of the jurors. And it's my understanding that you need to be a US citizen to take part on a jury. So you cannot basically be in the country under other circumstances and be called into that. And also this is a constitutional guarantee on the Constitution itself. So could you explain a little bit more to us, how is the relationship of the Americans and the jury system? And I'm pointing that out because you quite right said that in Brazil, we almost do not have jury trials. We have them only in criminal cases with the intention to kill someone. So basically intentional assassinate is pretty much the situation when we have them. So it's something that falls out of what we do when we think about going to court, definitely in civil cases.
It's that's another element of if you're a trial lawyer in the US, understanding how to present to a jury is very different from how to present to a judge. And it's really there is a bit of theater. You mentioned that earlier, that it all seems very theatrical. I can assure you that most trials are not nearly as interesting as the trials you see on TV, but there is a degree of theater. There's a degree of, empathy has to develop. But I think Americans have a very conflicted relationship with the jury system, and I'll explain what I mean. So first of all, when you go to your mailbox and you get this jury notice, they're still sending it by mail, which is weird. Your first reaction is expletive, okay? That is exactly what everyone says when they get this order, and it's an actual order. It's a summons from the court to appear on XYZ date. And your first reaction is, oh, expletive. But at the same time, we cherish it. And it goes back to our colonial roots and the development of our Constitution. So when you think about the sort of history of the United States, people came here looking for opportunity, fine, but they also came seeking individual rights and liberties. And what they found under British colonial rule was that a lot of those rights and liberties were being denied, and that there was a real lack of transparency and accountability in government procedures. So even though there was a separation of powers, the king really controlled everything. And, they would throw you away for years before informing you of the charges. And they would, there was a lot of concern for the lack of transparency and accountability in the British system at the time. And so the reason for the jury system was to bring transparency and accountability into a system. Transparency because ordinary people, not like us, but ordinary people get to see the system, get in there, and get to have a really significant role in the process to ensure that there's no impermissible collusion between the judge and one or more of the parties. And so that was really, really important to us. And even though everyone says, oh, expletive when they get called for jury service, people believe that's really, really important. And I think it's important in criminal cases, but I think especially in in civil cases, but particularly in criminal cases. And when we look at the race issues that we've been dealing with, it's not new. It's just that we're being forced to confront them in a way that maybe we haven't for a while. Does a Black kid who's charged with some crime, does he trust a judge who's so far removed from that kid's life in making decisions about his future, about his guilt, about these kinds of issues? And so I think at the end of the day, we feel very connected to the jury system. I think also there's another thing that has happened. There have been a lot of studies that they poll people after jury service and they say, what do you think? And they say, I think a lot better about lawyers a lot better about judges and a lot better about the whole system after serving. They see how serious it is. They see how much, that it's not just theater, that there's actually a little bit of substance behind it. And so I think it does do something, when people serve, they are more favorably inclined towards lawyers and the system than they were before. And it's both a responsibility and a privilege to serve. And I think jurors, from my impressions, people take it very, very seriously. And you're in the courtroom and you take this oath, and the judges there. I mean, we see judges all the time, but for ordinary people, it's really kind of a big deal. And to be in the presence of lawyers, they take it very solemnly. So I think we have a bit of a schizophrenic relationship with it, but I think the reasons why we needed a jury system in the first place, people would still feel, we still need that.
Fantastic. There is quite a bit of a cultural aspect on why jury is so important in the US. But I would like to direct the next question towards appeal. You said that there is almost no interlocutory appeals in the system. Normally, the rule is final appeals. And I also understand that it's pretty hard to get to the Supreme case. So to have a case heard before the constitutional case in the US Supreme Court is something very difficult to have. And I'm saying that just to give you the other side of the picture, that in Brazil, interlocutory appeals, they are pretty common. The new code, we have a new civil procedure code in 2015, so it's still pretty recent, tried to limit it, but then our Superior Court said it's limited, but well, not so much. We need to look into that. It's a mitigated limit, literally said that. And basically, civil litigation in Brazil is all to do about appealing. You get at least 3 levels of court hearings through appeals in every case. So if you could please explain more how it functions in the US and maybe the limitations in the system.
With respect to the Supreme Court, you're right, João. Getting to the Supreme Court is almost impossible. One of the greatest assignments to work on as a litigator is opposing a request to go to the Supreme Court, because you almost always win it. So let me explain. The Supreme Court has 3 types of jurisdiction. It has something called original jurisdiction. It almost never happens, where a case goes directly to the Supreme Court. These are cases involving ambassadors, ministers, consuls, and cases in which a state sues a state. So New Jersey sues New York. These just don't happen anymore because they're mainly boundary disputes and water disputes, and those have been resolved hundreds of years ago. The second way you could get to the Supreme Court is under something called the Supreme Court's mandatory appellate jurisdiction. And in order to invoke that jurisdiction, there has to be a federal statute that says these kinds of cases must be accepted by the Supreme Court when they are brought to the court, assuming procedurally they're correct. Now, back in the day, even when I was in law school, there were many, many, many cases of mandatory appellate jurisdiction. There were many statutes that required the Supreme Court to hear certain appeals. And in the last, I would say, not recently, but 20, 30 years ago, there was a big effort to limit that mandatory appellate jurisdiction. And there was some very effective lobbying in Congress. And so today, there are maybe 2 or 3 statutes that require the Supreme Court to review cases that fall under those statutes. Very, very, very few. So 95 to 99% of the Supreme Court's jurisdiction is discretionary appellate jurisdiction. And it's exactly what it sounds like. The court gets to decide. So they get about 10,000 cases a year brought under its discretionary appellate jurisdiction, and it decides only about 80 of them. And that's a very small number. And that's even, I would say 15, 20 years ago, it was 120, 125. I don't know if they're getting lazy or they've just sort of made some sort of informal institutional decision. You know, some of them are in their 80s. They don't want to work so hard. They do only 80 cases. So obviously, from the Brazilian perspective, this is absurd because in your constitution Supreme Courts, you have hundreds of thousands of cases probably, right? And so, you know, what people from Brazil and other places like it come to say, isn't that a due process violation that you don't have a right to have your case heard at the Supreme Court? So I think we view the Supreme Court a little bit differently. I think in most countries, you view the High Court, the Supreme Court, the Constitutional Court as a court of error correction. And I think we don't view our court as a court of error correction. We acknowledge that there are mistakes. We don't talk about it, but there are mistakes. We acknowledge it, we know it. There's no way, there's no mistakes, right? And the Supreme Court typically doesn't decide which cases to take on the basis of, oh, there might have been a mistake. The court instead is intended to be a court really of uniformity, of national uniformity. And so the times they're most likely to accept a case is when there's some sort of what they call a split between or among the circuits, when I showed you those different colored regions. When the Ninth Circuit interprets a law in a way that's different from the way the Second Circuit interprets that same law, then there's really a need for the Supreme Court to come in and announce a nationwide approach to the problem.
Fantastic.
Can I just say one more thing? The good thing is, so in defense of our system, my guess is that in Brazil, if you have a case at the Constitutional Court or the Supreme Court, it could take 15, 20 years maybe? Is that 10 years maybe?
Actually, to be fair, we had a case decided a couple of weeks ago that they still related to the Brazilian Empire. So it was a discussion if a palace in Rio de Janeiro belonged to the royal family or not. So this was just decided.
That's awesome. So that really is an extreme example, but you know what I mean? Yes. Our Supreme Court decides cases within a year. So again, it only decides 80. Yeah, they could get them done in a year. It's a balance like everything else, right? It's a trade-off between hopefully having all errors corrected and getting stuff decided quickly. And it looks like that our systems just sort of struck that balance in a slightly different way.
Fantastic. Maybe going out of what's normally regarded as civil procedure, but there is an important question that relates to the system of precedent and case law in the US. But the US also has quite a lot of statute law and, well, written law as one would think of it. I would like to ask you how those two relate, because when we think about common law in Brazil, we generally think about, well, it's all judge-made, they just have their precedents, and nothing is written down. So maybe if you could clarify how things are.
Sure. So, João, first of all, I'm impressed with your incredible knowledge of the U.S. legal system and the U.K. legal system. It's rare to find someone from outside the U.S. that knows so much to ask such great questions.
It was my summer course at Fordham who enabled me to.
That must be it. Must have been my lecture at Fordham. So I feel like you could teach this better than me already. And your English is actually much better than mine. Stare decisis and precedent is an odd thing. And I know that you guys have been struggling with it with your sumula vinculante and trying to sort of, it's an odd approach. But we've had it for much longer than you. And you're right, João. We have a lot, back in the day, right? Our system comes from the British system. And back in the day, there was very, very little legislation. And so stare decisis particularly made sense then because the judges had like no guidance whatsoever. They had no statute. They just sort of said, what am I supposed to do? So they would look at what other smart judges had done in similar kinds of cases. Now, eventually, as you say, you know, it used to be that a big difference between, say, our system and a civil law system was that we had very little legislation and you had a lot. I don't know if we have more than you or less than you, but we have a lot now. We have it at the federal level, we have it at the state level, we have it at the local level. The difference, I think, is a couple of things. One is how we interpret those statutes. We tend to interpret statutes narrowly so that we're not going to sort of infer an answer in a statute that doesn't address a particular problem. We also have a lot of statutes and our Constitution that are written with a great deal of ambiguity and gaps. So when you look at your Constitution, for example, you find a lot of social, economic, political rights outlined in the Constitution. We don't have any of that. I see we have a young student here. I'm very delighted. And I see he's going to also be a great musician as he grows up. We also have a lot of gaps and ambiguities, words that mean nothing. So we have due process, we have equal protection. What does that mean? It has no meaning without a judicial interpretation. And so we have these gaps and ambiguities, and we have this tendency to narrowly construe statutory law. So we essentially have three different kinds of common law. We have common law that is sort of true common law, where there's nothing written, right? And you see that a lot in the law of torts, for example, injury between people, an accident. We have then legislative stare decisis, which deals with cases involving an interpretation of statutes, which still leaves a lot of room for judges to work. And then we have constitutional stare decisis, cases in which the Supreme Court makes its own decision. We also have cases where occasionally you see a case where the courts take a very, very extreme approach. They will look at the language of a statute or the Constitution, and they'll do something that most of us would say is almost inconsistent with the statutory language. It's rare, but we have these circumstances where the courts have to sort of push us along, right? And the legislatures, the political branches just haven't gotten around to doing something, and so the courts just push us a bit. And so it's a very bizarre, odd system. And I think there are a lot of differences between the way your summa vinculante works and our stare decisis works. All cases in the US are precedent that can be relied on. And the courts don't perform some sort of summary of what they held. You have to actually read the case, and it lends itself to a lot of creativity, excuse me, where you could sort of argue different things about what that court decision meant. I don't know if that's a good thing or a bad thing.
Yes, well, we are still trying to find our way around precedents, and well, we have something very peculiar in this country, and we tend to relate it to, well, common law tradition, and well, I don't find so easy to make this association just in the way things are functioning in Brazil. But anyway, Rodrigo said that I have monopolized you for too long. So we have some questions from our audience. And the first one is from João Paulo Hacker, who is here with us. And he basically put out three different or complementary questions. I'll just make them to you so you may follow them. The first one is about—
1 second. I need to put a light on because it's getting to the point where I'm disappearing into the background. I'll be right back.
Okay, yes. And for everybody else, I just think that when we finish this question, anyone who is willing to make a question should just open the microphone and please.
Okay, that's better. I have an overhead light, but the bulb died and I haven't replaced it. And so I see that it's turning nightfall on my screen. So, okay. So João Paulo with a beautiful sun has 3 questions. Shoot.
Indeed. So the first one is about the length of cases in the United States. How long do they take to finish as an average? If you have any statistic data on how many cases settle and how many goes to trial. And the third question is about enforcement of court awards, if there is any difficulties in the enforcement system and how it functions.
Great question.
Good questions.
Length of cases, I don't know. I'm sure I could find out. If someone wants to send me an email, I could try to look into that. I think that federal cases are probably resolved more quickly than state cases because our state cases, our state courts are more burdened than our federal cases, than our federal courts. And the vast majority of cases, even in our system, do end up in the state court. So our federal courts seem to have broader subject matter jurisdiction than your federal courts, but still the vast majority of our cases do end up in state courts. I don't have an average, and there probably are some statistics that I could dig up. So sorry about that. Trial versus settle. So I could say this, I could say that in civil cases and in criminal cases, fewer than 5% of cases go to trial. The 95% then that don't go to trial either settle or get dismissed before trial on motions to dismiss or motions for summary judgment. My guess is that settlement accounts for most of those, probably 85 to 90% of cases. So it's a very small number that go to trial at all. And the third question, are there issues related, concerns or difficulties with respect to the enforcement of awards? I'm sure the answer is yeah. By the way, João Paulo, I'm doing a horrible job with your questions because I'm sure there are issues, but I don't know what they are. So I know that one issue we deal with through a full faith and credit provision in the Constitution, so that if I sue someone in New York and I get $1 million judgment, and then that person leaves New York and takes all her property with her and goes to California, I can enforce the judgment in California. But I'm sure there are difficulties with enforcement. I suppose the biggest problem is people who either are judgment free because they're broke, right? Or they somehow hide their money, right? So let's say you get a judgment against me for $500,000. $500,000 is all I have. And so what I do is I, send it offshore or hide it somewhere. And so I think probably the biggest problem with enforcement is actually getting the money out of unsuccessful defendants. But there probably are other issues that I don't know a lot about.
Fantastic. I would also just encourage everybody who's here that is willing to make a question, just to open the microphones and join us, or to send it in the chat here or on YouTube, and I'm more than happy to translate if that's the case, if anyone is willing to do that way.
Dear Toni, would you mind to explain us a little bit about the role of sheriff during the enforcement of court decisions?
The role of?
Sheriff. The sheriff. Is that a role in the enforcement of the decision, isn't it?
I'm not sure. I may not be understanding it, but I'm also not an expert in enforcement. So I may, could you say a little bit more about it?
No, because as far as I know, there is a role of the sheriff in the
sheriff.
Yes.
Sorry, the sheriff. I wish I had a giant sheriff's hat to put on. Yes, the sheriff. This is like the coolest thing, because you think, I don't know, when you watch these old Westerns that like, we don't have sheriffs anymore. We actually have sheriffs. There's even a sheriff in Manhattan, and I really want to meet him because I expect him to have a big hat and a big star. The sheriff, yes. So I don't have any idea what the role of the sheriff is, except this. I think that the sheriff is responsible. Let's imagine, Rodrigo, that I have a claim against you. You're living in the US somewhere, right? And you don't respond you're not coming forward with the enforcement. The sheriff will come out and actually seize property from you. So let's say you got a really beautiful Mercedes. Okay, I didn't really want a Mercedes, I wanted the cash, but if there's no cash, I'll take your $100,000 Mercedes, and the sheriff is the one that goes out and seizes your Mercedes for me. I love this concept of a sheriff. I'm not sure that a sheriff exists in every municipality, in every town, but the sheriff or sheriff equivalent will go out and work on that enforcement by seizing property. And the sheriff may also do, I don't know if the sheriff would do some investigation. So say, Rodrigo, you say you have no money. This is probably something that the lawyers would do, or hire a private investigation. We would follow you, right? And I would follow you to see, oh my God, you're going to that club? You got money, because you can't get in there unless you pay $1,000. So that's probably the role of a private investigator, but the sheriff will go seize your assets and make them available to me.
All right. Thank you very much.
You're so welcome.
We have a question from Bruno Magna.
Okay.
Bruno, are you willing to make the question, or should I? Yeah, okay, so he's not with a microphone, so, but he wrote it here to us. So the question from Bruno, Tony, is there any special comment about suing the government? Apart from civil rights and civil liberties, do people sue government before courts to demand public services? Or is it a matter for administrative judges only?
That's a great question. So the government is sued in civil rights actions all the time. Most other actions against the government will start as an administrative proceeding, and then you have the right to appeal, at least at the federal level, and then you have the right to appeal from the administrative setting to the court, usually to the Court of Appeals, sometimes to the district court.
So you actually skip a level on the judiciary system, the administrative.
Very often. I practiced administrative law, and the work I did, the statute provided that we go directly to the Court of Appeals on the theory that the administrative law judge, the proceeding before the administrative law judge was sort of sufficient fact-finding, that we didn't need to go to the trial court. But there are other administrative agencies at the federal level from which you do have to go to the district court. So it will depend. But I think you're right that most claims against the federal government are going to be through an administrative hearing first. Civil rights, not, for the example I gave before, if I sued the government for failing, for abridging my my First Amendment rights, my freedom of expression, I could go directly to court. But most of those contexts are going to come up in the administrative field. Maybe, João, we could take one more, and then I might need to go.
Yes, no, definitely. We have, is anyone willing to make another question?
Yes, I actually would like, but if there is no one else interested in making a question.
Yes, please.
Okay, Professor, thank you very much for the wonderful lecture. And my question is about issue preclusion. I've heard that in US, a few professors question the requisites that you have for recognizing issue preclusion in a second suit. And Brazil recently adopted a very similar institute in our Civil Procedure Code that was issued in 2015. So I would like your comments on this. If you think that the analysis of these requisites is too much time consuming, or if it's interesting because you can, how can I say, if you can use the same issues that were already decided, avoiding a new discussion on what was already litigated. So I would like your comments on this.
So the reason I'm laughing is because issue preclusion is one of those things that that I haven't thought about in about 15 years, but it's super important. And so I'm embarrassed that I haven't thought about it in 15 years. So I know that in general, so I'm going to give you a very, very bad answer. And Lillian, feel free to follow up with me, and I could try to send you some materials on that, but I would have to do research. My general impression is that issue preclusion is a great thing because it allows for efficiencies, right? And so the general idea of issue preclusion is a good one. My assumption also is that there are probably some huge defects in the way we handle it. And I know that I've read some of what you may be referring to, but I am not at all expert on it enough to be able to speak to it. But you and I can maybe speak offline, and I could try to find some good articles about that and maybe even share some more thoughts. So I really hate to leave on this this ending of me saying, I don't know, it's a very bad way to end, but it's also a very humble way to end. I'm amazed at how much, João and all the questions that you've all asked show a tremendous amount of sophistication about really hard issues. And I'm really, really impressed and hope that I at least could explain some things sort of well enough. And I'm sorry, Lillian.
No problem at all, Professor. Thank you.
Call me Tony, please.
Oh, I'm going to terminate this event here, and I'd like to thank for Toni to join us and to share your knowledge with us, and also to thank to João Lessa, that was the person that made this link with Toni to invite her to be with us here. So this was great for us. We learned a lot from you, and I expect that you can come again maybe next year and share more thoughts with us. And thank you for everybody to be with us in this event. And well, we'll see each other maybe next month in the next event. Thank you very much again.
Thank you all so much. It's an honor, and I'd come back anytime. Thank you all so much.
Thank you, Toni. Bye.
Thank you.